Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Kyle Cassidy, a New Jersey construction lien law guru. Today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Kyle Cassidy.
Thank you, Jesse. I appreciate that wonderful introduction. As Jesse just said, today's presentation is about what happens after I record my lien. How do I get paid? So obviously, we're taking it from the point of recording and moving forward towards foreclosing and hopefully getting paid. First thing I want to talk about with respect to the way we're going to handle the webinar. If you have any questions, please put them in the chat box to the right. We'll answer any questions at the end of the presentation. Please refrain from including any names or company names in the questions. Keep it generic if possible. All right, so the agenda. The first thing we're going to talk about is serving the lien, which is the first step in the process after recording in order to comply with the construction lien statutes in New Jersey. Then we'll talk about demanding payment and utilizing the prompt payment statute in New Jersey as a mechanism to hopefully leverage payment that you're seeking. The next step, assuming payment has been paid, we'll talk about commencing the lawsuit to actually foreclose on the lien. As part of that foreclosure process and the lawsuit process, the lis pendens requirement, what must be filed with the county register or clerk. Then we'll talk about litigation strategies, what are different mechanisms that can be utilized during the litigation to hopefully leverage payment, and then ultimately what happens at the resolution of the litigation. And lastly, we'll talk about SunRay and the resources that are available to you through SunRay. All right, so the first topic, serving the lien. So in New Jersey, there's two different statutes that are lien statutes for construction projects. One is it deals with private projects. That's the construction lien law. And then there's also the municipal mechanics law that deals with public projects where you're performing work on county or local entities, the ability to file a lien to freeze those project funds. But first we'll talk about the construction lien law and private projects. Once the lien is served, the statute requires that the claimant serve the lien on the owner and the contractor or subcontractor with whom they're in privity with within 10 days of lodging of the lien. Service must be made by either personal service, which would be like a process server who would physically hand the lien that's recorded to the owner and the contractor, subcontractor, or as an alternative, you could serve it by certified and ordinary mail. This means that the lien must be not only sent by certified, but also accompanied by a redundant mailing by ordinary mail. And it's sent to the last known business address or residential address. It will be important, obviously, to keep the records of how service was effectuated. So if you do utilize a process server, the process server will give you an affidavit of service stating the date and the time and the circumstances under which service was made. Same thing for certified or certified mailing. You'll want to keep that certified mailing receipt and have proof that delivery was made. And you'll want to hold on to that because it'll be necessary to prove that service was made as part of the litigation process should the lien not itself cause payment to be made. Note that service under the statute is a condition precedent to enforcement of the lien. This means that in order for you to enforce the lien, you can't do so unless service has been made. Now, if service is made outside of the 10-day requirement, it doesn't necessarily preclude enforcement of the lien. However, if the party who was not served can prove that they were prejudiced as a result of the non-service, then that could ultimately be a defense to the lien. So under the statute, disbursement of funds is prima facie evidence of material prejudice, meaning that if, for example, a lien was served late, and in the intervening time between when the lien was filed versus when it was ultimately served, an owner distributes payments to the contractor that otherwise could have been utilized to pay a subcontractor who filed the lien. Well, now that those payments have been made that otherwise would have been withheld, that owner has arguably been prejudiced because now they're out the funds that they could have utilized to satisfy the lien. So again, service is a very important requirement in light of that rule. The 10 days is a relatively quick turnaround, but it's certainly something that could be accomplished by simply engaging a process server or mailing out the lien by certified and ordinary mail. Another thing to keep in mind for purposes of, getting the lien served quickly, when you actually file the lien with the clerk, it's possible that the clerk will be able to get you a filed copy the same day. Not every county works that way, but there are certain counties where you can pay to expedite receipt of the lien and processing of the lien. So if it's a fairly large lien and a fairly important lien for purposes of the amounts that are due, you may want to explore whatever options are available to get a physical recorded copy of the lien as soon as possible so that service can be timely made and that all efforts can go towards collection. With respect to the municipal mechanics lien law, the public agency will serve notice to the contractor. And in some circumstances, they don't have to do this, but they can ask that proof be made by the claimant as to why, or by the owner or the contractor who the lien is filed against as to why payment shouldn't be made. In that circumstance, in a municipal mechanics lien, the lien is not an encumbrance on the property; it's on the project funds. So typically what happens is when a lien is served or on an entity, it'll freeze the flow of funds on that project. But it's in terms of service obligations, it's not as onerous as the private project statute of the construction lien law because service is actually made by the entity who receives the lien. Next step, demand payment and the Prompt Payment Act. So at this point, the lien has been properly served, and we're now at a stage where the lien claimant is doing everything they can to get paid. So typically, we will, before filing any sort of lawsuit to foreclose, we will demand payment from whoever payment is owed. So if it's a general contractor who filed a lien on an owner's project, the general contractor will demand payment from the owner. If it's a subcontractor who filed the lien, the subcontractor will demand payment from the general contractor. In that payment demand letter, the letter will indicate that an intent to file a lawsuit. Maybe it'll say, if we don't receive payment by close of business 10 days from now, we reserve the right to file a lawsuit to foreclose the lien. In addition, that letter should also reference the Prompt Pay Act, assuming that the act is applicable. The act would be applicable if, for example, a general contractor sends an invoice to the owner and the owner does not object to the invoice within 20 days of receipt and or doesn't pay inside of the 30 days billing cycle. Well, at that point, the statute is operative and would indicate that payment is due, because under the statute, if the owner does not object to the payment application or invoice within the first 20 days of receipt, then payment's deemed certified. And at that point, under the statute, it's owed. So the objections that could happen thereafter, under the statute, the claimant would have a basis to rebut. In addition, under the Prompt Pay Act, there's also mechanisms that allow a contractor or subcontractor to suspend performance without penalty if payment has not been timely made. So if a invoice has not been paid and a lien has been filed, the demand letter could include not only a request, a reference to the Prompt Pay Act and the fact that payments due thereunder, but it could also say if the performance is still in the process of being completed, there could also be a written notice saying we're going to suspend performance if we don't get paid. The notice requirement must be 7 days prior to any suspension. So the notice could include not only a demand for payment or threat to foreclose the lien, but also an indication that the contractor or subcontractor will suspend performance if payment's not made within the next 7 days. And if 7 days payment hasn't been made, then suspension, the claimant could suspend their performance without any penalty until payment is made, at which point in time the claimant would need to resume payment or resume performance. Lastly, the Prompt Payment Act, in addition to those other remedies, provides for interest, attorney's fees, and costs. This is important because the lien law itself doesn't provide for interest and attorney's fees, but the Prompt Pay Act will be a mechanism which the claimant could utilize to hopefully get paid. Now, again, all of these are being discussed in the context of leverage. The lien is certainly leverage to get paid. Prompt Pay Act can certainly be leveraged, and the various remedies it provides can certainly be leveraged to get paid. The idea with the demand for payment is to not only give the other party an opportunity to get paid, but make sure they understand what all of the leverage that the claimant has on their side, and hopefully in a cost-effective manner get paid. Assuming that the lien that the claim has still not been paid, the next step in the process would be to file a lawsuit. Under the construction lien law, this is again private projects, the lawsuit must be commenced within 1 year from the last date of work or the last date materials were supplied to the project. This is really important. I've seen it happen where a lien gets filed and sometimes the 1 year requirement, whether it be an attorney or a claimant, construes it from 1 year from the date that the lien was filed. That's not the law. It's 1 year from the last date of work. And if you miss that year deadline, your lien is expired and you don't have a lien anymore. The lawsuit must be commenced in the county where the real property is located. So if the property is located in Morristown, New Jersey, it must be filed in Morris County in Superior Court. The lawsuit must join the owner or the contractor or subcontractor who failed to make payment and any other person who has interest in the real property. This would include other lien claimants. The law requires the court to stay the lien foreclosure lawsuit to the extent that there's an operative arbitration agreement or other dispute resolution form agreement. So if the contract requires that that any dispute be resolved in arbitration, for example, the AAA, then what would happen is you file the lawsuit and then the lawsuit would be stayed during the time that the dispute over payment is resolved in the arbitration. Once that dispute is resolved, then the lawsuit can proceed. And again, it would be important to file that lawsuit even if there is an arbitration requirement in order to make it fall within the 1 year requirement of the last date of work to prevent the lien from expiring. Note that the lawsuit doesn't need to just include a foreclosure count. It could also include a breach of contract claim. If you're a subcontractor who has the lien, you'll include a breach of contract claim against the general contractor. You'll include a count for under the Prompt Pay Act and seeking to recover attorney's fees, costs, and interest. You can also include quasi-contract claims to the extent that there's any unsigned change orders or any non-contract type of claims that the claimant has against, whether it be the owner or general contractor. For the municipal mechanics lien, the lawsuit to enforce the lien must be brought within 60 days from the time when the whole work performed by the contractor is either completed or accepted by the public agency. So it's not until after the project is fully accepted. The lawsuit must name the contractor, subcontractor, and public agency, and any other party who filed the lien. Lawsuit must be commenced in the county where the public agency is located, and the lawsuit, like the construction lien law, can include other causes of action. The lis pendens requirement. So this is specific to the construction lien law and private projects where the lien actually is an encumbrance on the property itself. So under the law, when the lawsuit's filed, there must also be another filing with the actual county itself. That's called a lis pendens. It's a document that gives notice. It's a recorded document that gives notice to the world of the pendency of the foreclosure lawsuit. The lis pendens will be filed in the county clerk's office or county registrar's office where the property is located. So if it's again, Morris Township property, then it goes to the Morris County clerk or registrar's office and filed there. The lis pendens itself must provide written notice of the pendency of the action. Typically, we'll have the actual caption of the lawsuit. So it'll include the various parties to the lawsuit, the docket number, any other indication of who the parties are. It must also include a description of the affected real estate, which will include all of the legal description of the property itself. Typically, you can get a legal description of the property through the various public portals that the different counties operate, which include all of the deeds and the public property information that are available. Deeds will typically include a legal description of the property. You could use that legal description to describe the real estate that's affected. Administrative requirements. So every county in the state of New Jersey requires that a filing with the county include there have been times and horror stories where the actual physical documents, whether it be a lis pendens or a lien, have been rejected for failure to include a cover page. It seems very mundane or ministerial, or simply just like it should be correctable. But if it's not included, these documents will be rejected. And if the timelines are very narrow, you don't want to have a document be rejected by the clerk or register for failure to have a cover page. You'll want to look at before going to the clerk to know what the filing fees are. Certain filing fees require a fee for the first page and a certain amount of additional dollars per page thereafter. It's always best to just call the clerk or registrar in advance, know exactly what the requirements are, know exactly what the filing fee requirement is, and know exactly what you need to bring with you to get this document required. Because again, it's going to be very important, and it could ultimately jeopardize your ability to foreclose on the lien. Tying into that, I've had situations, especially around COVID, where some counties will not allow a filing to occur unless there's an appointment. So if you show up and walk in with the paperwork and try to get something filed that same day, there has been situations where that request has been rejected because you didn't have a prior appointment. So whether we're talking about filing the lien itself or filing the lis pendens, you're going to want to know in advance whether or not, if you're doing it in person, whether or not whether you need to make an appointment in advance. And you'll want to obviously do that with some time to spare, because the appointments may or may not be available on the same day. Now we're moving towards the litigation itself. So at this point, the demand letters was unsuccessful. We filed the lawsuit, we filed the lis pendens, and we're now in the midst of the litigation. And we're doing what we can do to try to recover on the lien and what we could do to expedite that recovery. One thing that may happen during litigation is that the lien may be bonded off, which is a surety bond would be deposited and placed in the stead of the lien itself. So the lien would basically be removed from the property. It would no longer be an encumbrance, but there's now a bond that could be recovered against. So there's a guarantee, a financial guarantee, that if there is a foreclosure of the lien, that the amount will be paid by the bonding company. So if a bonding company discharge the bond, that would typically be either done by the owner itself or a general contractor, assuming the lien was filed by a subcontractor, then the bonding company will need to be added as a party to the lawsuit. In addition, the discovery process could be a fairly useful tool to get paid. Obviously, if a lien was filed by a subcontractor against the project because a general contractor didn't make payment, well, that's going to cause some friction between the owner and the general contractor, because the owner isn't going to want and a lot of times there's language in the contracts that require general contractors to keep the properties free of liens. So by serving discovery on the owner for payment information, for communications, by making their life a bit more difficult, it's going to make things a little bit more difficult on the general contractor, because now they're hearing it from their client that they're unhappy by what's happened. So typically that could cause the owner to put enough pressure on the general contractor that payment may be made by the general contractor. There also may be other avenues of recovery. So I'm dealing with a couple issues right now in New Jersey where there are general contractors who are not able to perform. They're having financial difficulties, but there are other financiers coming in and taking over those projects and completing. Well, in those circumstances, those replacement contractors or financiers may be a source to obtain recovery. So sometimes you have to just pay attention to what's happening on the project. See, if you know a general contractor who you did not receive payment from is having payment issues, but you know that the project is now, that was once stalled, is now continuing, you're going to want to know everything about how it's continuing and about who's continuing it and whether or not that may be an available avenue to obtain recovery on the lien and to get paid. Litigation resolution. Through the construction lien law, you'll ultimately work your way towards hopefully a settlement. And in that case, if there is a settlement, then it's typically memorialized by a written agreement between the parties with releases and ultimately a discharge of the lien and lis pendens. So if there is payment during the lawsuit process, then what will be required is that you'll have to file paperwork with the county clerk to discharge the lien and to discharge the lis pendens. Those papers are similarly formulaic as it is filing the lien and filing lis pendens. They need the cover pages. There's filing fees associated with them. There's specific black and white rules that must be followed. But once you're paid, you can't continue to have a lien. And once the lawsuit's resolved, then there is no pending action. So the lis pendens needs to be discharged. So don't forget, if you've gotten paid, to discharge your lien and lis pendens. If settlement has not occurred, then we move towards the foreclosure process, which is ultimately you're going to have to substantiate whether or not the amount is due and owing. And if you can, then the judgment of foreclosure you will recover through the court a judgment of foreclosure on the property, which will actually or potentially against the bond. So if you're successful in the lawsuit, then you'll either force us ultimately get you paid through distribution of the assets based upon priority. If there's multiple liens that have been filed, then the first time liens will get paid first from the proceeds, and if there's any amounts that are left over, then they'll be distributed in accordance with the law. But if you're the priority lien holder and the proceeds get you fully paid, then that's really the intent of the statute. If there's a bond that's been recorded, then there will be no sale of the property, but the recovery will happen basically through payment by the bonding company or by the party who obtained the bond themselves. But again, the bond is there to guarantee full payment, assuming that the lawsuit is successful. For public projects, the court would ultimately determine the validity and priority of liens and direct that the public entity pay the amount due from the withheld funds on the public project. At this point, that kind of summarizes the process. So if there's any questions that anyone has, I'm happy to answer them.
Well, first of all, Kyle, thank you so much. That really was some great information you were able to give to us. I do have a question that has come through. It says, can I still lien or file a claim on the bond for a job that I never sent a preliminary notice to? And is there a difference between private and public jobs for that?
So it depends on what type of bond we're talking about. In the context that we're talking about these bonds, we're talking about a lien bond. So a bond that's a lien bond it's also a bond obtained through a surety, but it's obtained after the lien has been filed, and it's intended to replace the lien itself. It seems from the question that's what's being talked about is a lien on a payment bond, which in public projects in New Jersey, there's a statute that requires every public project to have a payment bond and a performance bond that are there for the benefit. Well, the payment bond, I should say, is there for the benefit of claimants or downstream subcontractors. In that context, if a subcontractor of a general contractor on a public project has a claim against the bond, then their claim does not need to have a prior notice to the owner or general contractor. But if you are a sub of a subcontractor or a supplier to a subcontractor, then yes, a notice would be required. And it depends on the circumstances, but that notice requirement, if it's not met, could certainly be a basis to disqualify you from recovering on the bond. But again, the bond, it seems like in this situation, if you're recovering on a lien bond, which is what this presentation is talking about, there's no notice requirement to the surety or to anyone on the bond, because the bond is obtained after the lien has been filed and recorded, and it's after typically it's after the recording. So at that point, it's just replacing the lien.
Okay. All right. Thank you. All right. The other question that came through is there any exception to extend the deadline to file suit to foreclose after 1 year of when the work was performed?
No, you need to make sure you meet that deadline. It's a black and white rigid rule. I've seen lawsuits dismissed because, again, people have thought that the 1 year was running from the date of the filing of the lien, not the last date of work. Obviously, given that liens need to be filed within 90 days of the last date of work, there's going to be potentially as much of a 90-day difference in time between those two events. So it's very important when you file a lien, what you should do immediately after is file or put a calendar reminder or whatever calendar you utilize. Make sure to go a year out from that date of the last date of work, which will be expressly stated in the lien document. Go out a year from that date and calendar your deadline to file the lawsuit. frankly, you should calendar intervening deadlines that are giving you reminders. Hey, we're 2 months out from the deadline. Let's either retain an attorney or do what I need to do to get a lawsuit filed. Because if you miss that deadline, there really is there's no other exceptional circumstances or way around the 1 year deadline.
Okay, wonderful. Yes, please don't wait until the very last moment. You need to make sure that you're giving your attorney and your case in general just enough time for that preparation to actually file suit. So don't wait until the day before your deadline.
Yeah, and again, don't misconstrue the dates too. You know where the dates run from, because that could be the biggest mistake.
Yep, for sure. Okay, and then another question that came through. So once you have been paid and you need to settle out your lien, it says, do you need to have individual discharges or releases for the lien and the lis pendens?
Yes, it's a good question. So since they're two separate documents, and a lot of times they're filed in two separate offices at the county, I actually just did this yesterday. I had to send two separate letters to two separate offices in Union County, stating that I wanted a discharge of the lien and a discharge of the lis pendens. So there was different filing fees for each. I had to have two cover pages. So yes, one does not satisfy both. You need to do each individually, and that also works on the front end. The lis pendens is a separate document, and then the construction lien. So both need to be filed separately as well.
Okay, perfect. Thank you so much. I do think that that's all the questions that have come through. If anyone does think of another question, please feel free to reach out to myself or to Kyle, and we'll be sure to answer any questions for you. Can you go to the next slide for me, please?
Sure.
All right. So these are some of SunRay's resources that we have available to you. Please go ahead and scan that QR code. We've got a lot of great resources to help you stay organized, know your deadlines. So please check that out. I do encourage you to do so. If you're working in a nearby state, please remember each state has its own unique lien laws, deadlines, documents, everything. So please check it out so that way you're better protected. All right, and then the next slide for me.
Oh, let's see. There we go.
Thank you. All right, our next webinar with Kyle is going to be Getting Paid Faster with Liens, Bonds, and Contracts. That's going to be August 14th. So please register for free at sunraynotice.com/education. We hope to see you guys there. And then the next slide. If you don't mind, take a quick moment to give us a review on Google. We really do appreciate it. Any of your feedback, we really take it to heart and try to make sure that we're improving ourselves and our services of what we can offer to you. And then the next slide, please. All right, and with that, that is all we have for you guys today. Thank you so much for everyone that attended. We hope to see you at our next webinar. Again, Kyle, you really are incredible, so I appreciate it. Thank you so much. I hope everyone has a beautiful and sunny day. Thank you, everyone.